Right. You said the matter is for adoption of final written addresses.
Yes, my lord.
Yes.
My lord, our final address was filed on the 25th day of June, 2021.
Yes.
My lord, we also have a reply on points of law that was filed on the 9th day of February 2023. My lord, on the last adjournment date, my lord might recall that we had hinted to the court that we had not received the claimant's written address, upon which my lord directed that they serve us and we file within 48 hours.
Yes. Did they serve it on you?
He afforded me a copy of it, upon
Okay.
which I proceeded to file a reply on points of law.
All right. You want to adopt the final written address?
Yes, my lord. I pray to adopt the final written address filed on the 25th day of June 2021, and the reply on points of law filed on the 9th day of February 2023 as our arguments in this case, and urge my lord to dismiss this suit.
All right. Now, what about the claimant's final address? Are you there, Mr. Uriam? It has gone off again.
I'm here, my lord.
Yes, the claimant's final address.
Yes, the claimant's final address was filed. So it was filed on the 21st day of March 2022.
Yes.
Yes, my lord. My lord, I pray my lord deem same as adopted.
All right.
Yes, my lord. If my lord will just permit me a few minutes to adumbrate.
Yes.
My lord,
I'll give 1 minute.
Yes, my lord. My lord, the fulcrum of the claimant's case is simply that he's entitled to benefit from the pension, from the condition of service of senior staff.
Yes.
Now, my lord, that condition of service is peculiar to members of Pengerson. It is boldly written there. That is for members of Pengerson. Now, my lord, the claimant is also a management staff and not a member of Pengerson. No checkup dues was ever deducted from his salaries. He admitted to that fact that he's not a member of Pengerson. So, my lord, what we are saying is that not being a member of Pengerson, he is not entitled to benefit from this condition of service. It's as simple as that. My lord, he went further to say that there was a circular that preceded the condition of service, that it was by virtue of that circular that he ought to benefit. And he was also told that he was meant to benefit. My lord, all those were in the realm of hearsay. He said they told him that he was meant to benefit. My lord, we also made reference to Section 3 sub 3 of the Trade Union Act, to the effect that the mere fact that he's a member, he's a projection of management. The mere fact that he's a projection of management, he cannot be said to be a member of, he cannot be said to be a unionist, as that would amount to, that would create a situation of conflict of interest.
Yes.
So, my lord, in the main, we had maintained that he's not, by virtue of the fact that he's not a member of Pengerson, that condition of service does not apply to him, and he cannot benefit from that. In fact, he has also been paid his his terminal benefits, his due terminal benefits. His only grievance is that he wasn't paid in line with the condition of service.
When he was terminated, did you pay his
Yes.
terminal?
Yes.
No, when was it terminated with a month's notice? With or without notice, his termination?
My lord, he was terminated with notice.
Oh, he was given 1 month.
Yes, his problem is not with the termination. His problem is with the salaries not being in line with the senior staff condition of service. That is his challenge.
But you gave him his 1 month's notice.
Yes, we gave him everything due him.
It's not as though you terminated his employment and then he just left without collecting anything.
No, my lord, if my lord looks at his prayers before the court, he's not even asking about wrongful termination.
Because I noticed that there wasn't any letter to that effect, stating that he was entitled to a month's salary in lieu of notice or anything of that nature.
My lord, that is not amongst his grievance. He doesn't have any grievance with the method of his termination.
Even though a claimant doesn't make claim for such, where the court finds it is he's entitled to it, he will be awarded with such benefits, whether it's a claim. That is what judicial authorities say.
Yes, my lord. My lord,
notwithstanding, it is all right since you said it wasn't as though he made any claims of such.
Yes.
We'll have still been in order to make an order, regardless of whether or not it was claimed, assuming he was not paid. That's what I'm trying to say.
I appreciate my lord's position. My lord, but that is not the case in this instance. My lord, if my lord looks at the final address of the claimants, their contention was that there was an oral.
I'm very sorry, my lord. I'm very sorry, my lord.
Yes, Mr. Ejua.
I'm very sorry, my lord. I've been trying to join. Network has been disturbing, sir.
All right. Enter appearance.
MU Ejua, my lord.
Okay.
My appearance is for the claimant.
All right. Now, let's conclude with the defendant counsel.
Yes, my lord. My lord, I'm sorry, I don't know the matter we are treating now, sir.
This should be 437. Akwarandu, Chinweba.
As the court pleases. As the court pleases.
That's right. Okay. So the defendant's counsel was just about to round up. He has adopted his final written addresses, both the one he filed initially and the one in response to yours. And he has even sought that yours be deemed as duly adopted in accordance with the rules of this court.
As the court pleases.
He was merely trying to elaborate on one or two things before you join the session. So perhaps we can continue we will conclude with him and then come back to you.
As the court pleases.
All right.
Yes, my lord. My lord, I was only going to say that in the claimant's written address, he had raised an issue of oral contracts between the claimants and the defendants. My lord, to that we have stated in our reply brief that parties are bound by their pleadings. That there was never any mention of oral contracts in their pleadings. So that the issue of oral contract is neither here nor there. It's not an issue before the court. So that they cannot come to raise issues that were not pleaded and rely on that before this honorable court.
Yes.
Yes, my lord. So, my lord, we'll be praying, my lord, to dismiss this. And we also place reliance on the decision of this honorable court, which is in all falls with this suit of your learned brother, Justice Hammond. Which was delivered on October 15, 2021.
Yes.
Yes. Between Mr. Inform Michael Jeremiah versus Tecon Oil Services Limited.
Okay.
So me, please, my lord.
Right, Mr. Jua,
Yes, my lord.
you only have 1 minute to adumbrate if you need to.
My lord, I don't think I have any need for adumbration, my lord. My written address speaks for itself adequately, my lord.
Very well then.
Yes, my lord. And my lord, I will only apply that the written address filed on the 21st of March, which has been adopted, be deemed as properly filed, my lord. To be deemed as properly filed and served.
21st of March, 2022.
Yes, on the 21st of March, 2022, my lord.
Be deemed.
We filed out of time.
Yes.
Be deemed as properly filed and served, my lord.
Okay.
We are very grateful, my lord.
Yes, my lord. You will, I'll give the judgment immediately. It will be
as the court pleases. We are very grateful, my lord.
The matter all over. So you bear with me. I'll perhaps read the most vital aspects of the judgment. You'll get it immediately after court proceedings today.
As the court pleases.
So take a listen. The claimant was employed by the defendant as a service/business development contract engineer on the 5th of August 2002. He worked in that capacity until the 1st of February 2016, when his employment was terminated by the defendant. Following his disengagement, his employer, the defendant company, assessed the claimant's terminal benefits to be 8 million naira, out of which 4.720 million naira only was paid directly to him, while the balance of 3.280 naira was assessed and deducted as the value of the claimant's official vehicle in his possession. The claimant first demanded for what he believed to be his actual entitlement from the defendant in the sum of 24.37 million naira, vid letter dated the 11th of July 2011. I believe that should be 2016. I beg your pardon.
As the court pleases.
But to no avail. The claimant thus approached this court for a redress of what he considers as a deliberate withholding of his due entitlements by the defendant company. I will proceed straight to the judgment part, my decision. Court's decision. I carefully read through the final written submissions by both counsel in line with their arguments on their issues for determination. I equally evaluated all the evidence adduced in this suit. Having joined issues and concluded trial, it is incumbent on this court to make its findings based on all that has been presented. As such, I am satisfied that the sole issue for determination should be whether the claimant is entitled to the sum of the 23,292,019 naira 0 kobo claimed. I shall determine this sole issue on the strength of the facts and evidence adduced by both parties. It is clear that both parties contest the entitlement by the claimant to that sum, which is the sum of 23.2 million naira. The facts referred to are contained in paragraphs 17 and 18 of the claimant's amended statement of facts as follows. I quote 17. The claimant avers that the total terminal benefit due to him was 28,012,019 naira, but the defendant had only paid the sum of 4,720,000 naira. remaining the sum balance of 23,292,019 kobo. 18. The claimant avers that by virtue of his position as a management staff with the defendant, his entitlement is 28,012,000 naira 19 kobo. Now, particulars of the claimant's entitlement as per the conditions of service of the defendant, which shall be relied upon at the trial of this matter, has been presented. The claimant is apparently miffed by the calculation of his terminal benefits to a paltry 8 million naira by the defendant, and did in fact, as by Exhibit C7, express this displeasure via a letter dated the 11th of July 2016, written by his solicitor M.U. Ejua Esquire, wherein he demanded for the sum of 24,637,019 naira and 637,019 naira 23 kobo from the defendant company as his full terminal benefits. The law is long settled on whom the burden of proof lies in any civil suit, and the standard to which a litigant must prove his case to merit the decision of the court in his favor. Therefore, whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove that those facts exist. You may see Section 131 of the Evidence Act, 2011. It goes without saying that the court has the simple duty to consider all the evidence adduced by both parties on the issues joined. In order to substantiate his claim to the sum of 23,292,019 kobo and 19 naira, therefore, the claimant particularly tendered and relied on the following documents. 1. The claimant's letter of employment dated the 5th of August 2002, Exhibit C1. 2. Conditions of service, Exhibit C3. 3. Communiques dated the 14th of November 2013 and the 23rd of January 2004, Exhibits C4A and C4B. 4. Conditions of service 2002 to 2004, Exhibit C8. 5. Conditions of service 2004 to 2006, Exhibit C9. 6. Conditions of service 2006 to 2008, Exhibit C10. And 7. Conditions of service 2008 to 2010, Exhibit C11. Considering the nature of the claimant's employment in the defendant's company, which is purely master-servant, the decision in Union Bank of Nigeria Limited versus Ogbo, citation supplied, readily calls to mind, and same is aptly reproduced as follows. Except in employments governed by statutes, wherein the procedure for employment and discipline, including dismissal of an employee, is clearly spelled out, any other employment outside the statute is governed by the terms under which the parties agreed to be master and servant. I reckon that the claimant bases his claim upon supposed calculations modeled from the conditions of service contained in Exhibits C8, C9, C10, and C11. These documents have boldly engraved on each of the cover pages conditions of service for senior staff. Meanwhile, the claimant stated under cross-examination that his letter of appointment was accompanied by the said senior staff conditions of service. It is, however, unassailable that from the contents of Exhibit C1, the claimant's letter of employment, no reference is made to any conditions of service for senior staff. However, the claimant insists that those conditions of service for senior staff were attached to, and they accompanied his employment letter. it is imperative to reproduce the evidence elicited from CW1's cross-examination in open court on the 24th of April 2018 and the 7th of March 2020 as follows. 1. Question. You know that management staff are not unionists. Answer. Yes, I am aware. 2. Question. You are not a unionist. Answer. I am not. 3. Question. This case is solely on your behalf. Answer. Yes. 4. Question. See clause 3 of exhibit C11. The agreement made between Pengerson, Nupeng, and the defendant. Answer. Yes. But I have an exception. We were given the conditions of service upon our employment. All our entitlements are based on the document. I actually have no trouble whatsoever in believing the claimant's oral testimony that a condition of service, perhaps exhibit C3, was given to him upon his accepting his employment, more so since this claim was never denied by the defendant. However, the law cannot be foiled, as our case and evidential laws specifically provide that save in special circumstances, an oral or verbal testimony cannot vary or contradict the contents of any document. You may see section 128 of the Evidence Act, and there are abundance of legal cases, judicial authorities to back that principle. Now, unless and until there is credible evidence to suggest that a contract of employment was amended verbally by an employer, or that certain terms which were verbally made were impliedly incorporated into such contract of employment, the law still remains that the contents of a written document cannot be amended orally. It is the law that where parties have embodied the terms of their contract in a written document, extrinsic evidence is not admissible to add to, vary, subtract from, or contradict the terms of the written instrument. You may see Onogen JSC in Lamy versus Data Processing Maintenance and Services Limited, citation supplied. I fail to see how exhibits C3, C8, C9, C10, and C11 were incorporated verbally into this claimant's written employment terms as argued furtively by his counsel. If the claimant wants this court to believe him, then perhaps he should have corroborated his testimony with that of the human resources manager, who was accordingly responsible for making a representation that exhibit C3 would be binding and enforceable on him, or by producing other pieces of credible evidence in that regard. I respectfully reject the unconvincing submissions and arguments made by my learned counsel for the claimants on this issue. Besides, I quite agree with the defendant's counsel that the arguments made by the claimant's counsel on the above issue are unsupported by any facts in the claimant's pleadings. Arguments or addresses of counsel, no matter how delicately and beautifully presented, cannot take the place of evidence. Therefore, the claim that one Musa of the HR department informed these claimants that the terms and conditions of service for senior staff are incorporated into his letter of employment is an incurable and an inadmissible second-hand tokumbo or hearsay evidence. There is no doubt that exhibits C3, C8, C9, C10, and C11 are all labeled conditions of service for senior staff. Meanwhile, exhibits C4, A, and B are communiques resulting from meetings had with the management staff of the defendant, with the members of both unions of Pengerson and Nupeng, dated respectively as 14th November 2013 and 23rd of January 2004. The claimant never suggested that he was at any point in time a member of any of those unions or that his name was stated in any of those documents. He tended to infer that the contents of those documents were binding and enforceable by him. As my Lord Haman J. most recently puts it in his decision in Umfong Michael Jeremiah versus Tecon Oil Service Limited, Supra, I quote, "It is clear from the claimant's evidence that he was not a member of either Pengerson or Nupeng. If one of the ways of determining membership of a trade union is the payment of union dues, I then wonder how someone whose salary was never deducted for union dues and never paid such dues can claim membership of a trade union and also take benefits from agreements reached by the trade unions for the benefits of their members. I therefore hold that the claimant, not being a member of Pengerson, cannot take benefit of exhibits CW3, CW4, CW7, CW8, and CW9. The said exhibits are therefore not applicable to him." End of quotation. You may also see the decision of my brother Bashar J. in Emeka Ben Obialemba versus Tecon Oil Service Limited, delivered on the 18th of February 2019. Significantly, exhibits C11 as well as exhibits C8 to C10. I'm sorry, exhibits C3, I beg your pardon, as well as exhibits C8 to C10, all contain the following clause. I quote, "This agreement is made on the 12th day of February 2009 between Petroleum and Natural Gas Senior Staff Association of Nigeria, Pengerson, Tecon Branch, hereinafter referred to as the association, and Tecon Oil Service Nigeria Limited, hereinafter called the company." End of quote. Clause 3 of Exhibit 3, Conditions of Service for Senior Staff 2011, states clearly as follows: "The terms set out in this agreement shall be binding on the company and all regular employees of the company who are members of this association," which is Pengerson. I believe we had a technical hitch there.
Yes, my lord.
All right. Now, I'll take the last statement from the beginning. Evaluating the contents of the exhibit C8 to C11 vis-a-vis other evidence before this court, I am most convinced that these evidence are self-destructive and do in fact emasculate the case of the claimant. I have no trouble whatsoever in discerning that the claimant is neither a member of the Petroleum and Natural Gas Senior Staff Association of Nigeria, Pengerson, nor of the Nigerian Union of Petroleum and Natural Gas Workers, NUPENG, who are the only parties contemplated in those terms and conditions for senior staff exhibited here by this claimant. I am therefore baffled why he wants to enforce the provisions of the state agreements in computing his terminal benefits, being the formula provided in those documents. This indeed was an ambitious venture. Now, it is trite that only a party to a contract or agreement can enforce same if it was made for his benefits. This is recognized in the principles guiding privity of contracts. The case of Basinco Motors Limited versus Rubberman Line and another citation was cited and relied upon in the case of Idufo Idufueco versus Pfizer Products Limited and another, it must be emphasized that the claimant here stated on the cross-examination that he commenced this suit for himself. Therefore, there is nothing to suggest that he instituted this suit on behalf of the members of Pengerson or any other association. For this reason, it would be pure academic voyage in futility to dissect the true nature and purport of exhibits C8 to C11. Such venture shall not by any means impart any utilitarian value on the case of the claimant. The claimant is alien and not privy to the contents of these documents, particularly since it does not assert any representative rights on behalf of the who are the sole beneficiaries or as a representative of the defendant company. As such, I so find. It is quite needless to point out that the collective agreements can only become binding if there is clear proof that they have been incorporated into the terms and conditions of an individual employee's contract of employment by his employer. This is, however, not the situation here. Meanwhile, DW1 stated on the cross-examination that the claimant's terminal benefits depend on his contract of employment with the defendant company. It has been firmly decided and held that where words used in a document are plain and literal, court must restrict itself to their ordinary meanings without any importation thereto. For the umpteenth time, exhibits C8 to C11 are unhelpful to this claimant's case. Therefore, building his claims upon these exhibits amount to placing something or nothing, which is an abstract endeavor which can only be achieved imaginatively. This is the case of the claimant. The claimant stealthily seeks an order for this court to compel the defendant to pay him the sum of 23,292,019 naira 0 kobo as his supposed total terminal benefits by virtue of the terms and conditions of service for senior staff on the strength of exhibits C8 to C11. This court has taken notice of the contents of exhibit C7, the claimant's letter of demand for his due terminal benefits from the defendant. Curiously, this document puts the purported entitlements of the claimant at the sum of 24,637,019 naira 23 kobo, which is different from the sum now claimed in this suit. It is, however, not clear from the contents of the state exhibit C7 how the claimant arrived at those figures demanded therein. Be that as it may, the material question is what exactly has the claimant been able to prove thus far as his entitlements? Under the employment jurisprudence, the claimant carries with him an evidential burden to prove his case on a balance of probability, Section 134 of the Evidence Act 2011. I wish to add here too that it is until such burden is discharged by the claimant, the defendant has nothing to disprove. The claimant can only succeed on the strength of his own case and not on the weakness of the defenses. Well, the flip side, however, is that since his employment is terminated by the defendant, he may be entitled to have been given a month's notice before the said termination and or be paid a month's salary in lieu of the termination if the defendant has not already paid before he instituted this matter. I hereby order the payment of his 1 month salary in lieu of such notice for termination if same had not already been advanced to this claimant. Even if this is not expressly claimed, this court can still award it, since the law is that where a servant's employment is terminated, he is entitled to be paid all outstanding monies owed, including any salary in lieu of the required notice before such termination. It is relevant if the claimant pleaded for the relief or not. You may see the recent Supreme Court's decision in Toyimbo versus Union Bank PLC, citation supplied. So in determining in whose favor the overall weight of evidence so far adduced by both parties tilts, the sole issue for determination in this judgment must be answered against the claimant in favor of the defendant, and I so hold. In conclusion, I find no merit in the claimant's suit, and same fails in its entirety. No court ordered. Judgment is entered accordingly.
As the court pleases. My lord, we're most grateful for my lord's well-considered judgments. We're most obliged.
Thank you, Mr. Ejua.
Yeah, my lord, we are very grateful. We appreciate this judgment. It's a wonderful one, my lord.
Thank you.
We'll get a
copy of it immediately after proceedings today, and within 5 minutes online. You'll get it online on our portal.
We are grateful, my lord.
That concludes our case, the case for 437.
437.
Yes, ma'am.
Please call the next case.
Suit number NICN/YEM/439/2016. To Mr. Okechukwu Obi and Tecon Oil Service Limited. Thank you.
All right. This is Louis E.K. Obi.
As the court pleases.
Right.
We are very grateful, my lord. We are very grateful, my lord.
Now, yes, parties, are they in court?
No, my lord.
Okay. Yes, appearance?
With humility, my lord, M.U. Ejua. My appearance is for the claimant.
Okay.
Yes, my lord.
May you please, my lord?
Yes, please.
May you please, my lord? Most respectfully, I am C. Uriam.
Right.
I most humbly appear for the defendant. Most obliged.
Yes, please. Yes, defendant, any application?
Yes, my lord. My lord, the matter is for adoption of final addresses, and subject to my lord's convenience, we're ready to proceed. My lord, final address was filed on the 25th day of June 2021, and reply address filed on the 9th day of February 2023. Subject to my lord's better direction, we're ready to adopt our final addresses.
All right. Yes, Mr. Ejua.
Yes, my lord. My lord, we filed the claimant's final address on the 13th of January 2022. And
13th January, right?
yes,
13th?
my lord. 13th January 2022.
Yes. And
we filed another one, my lord, on the 21st of March 2022.
1st March 2022, yes?
Yes, my lord. My lord, we humbly apply to withdraw the claimant's final address filed on the 13th of January 2022.
Any objection?
No, my lord, no objection.
Granted as prayed.
Yes, my lord.
The final address filed on 13th January 2022 is hereby struck out.
As the court pleases, we are very grateful, my lord.
Yes.
My lord, yes, we seek the leave of court to apply that the claimant's final written address filed on the 21st of March 2022 be deemed as properly filed and served.
Okay.
Since it was filed out of time.
Okay.
Yes, my lord, we adopt it as our argument in this case.
Sorry, I thought I was meant to adopt first. I only
I thought you've done that. I'm sorry. I thought you've done that. Sorry about that.
No, I thought you said subject to the court's direction, we wish to adopt this.
Yes, I heard something like that, my lord.
Yes, my lord. I was
Yes.
only waiting for my lord's better direction to adopt.
All right. So, okay, yes, you can go back to your adoption if you want to.
Yes, my lord. I most humbly adopt our final address filed on the 25th day of June 2021, and our reply address filed on the 9th day of February 2023.
Yes.
And yes, if my lord is minded, I will only speak for less than 1 minute.
Anyway, meanwhile, before then, your application, the claimant's application to have his final written address of the 21st of March 2022 be deemed as duly filed and served is hereby granted as prayed.
As a copy, please.
I'm very
All right,
grateful.
yes, Mr. William.
My lord, I will only speak on one.
Yes.
I would only speak on one issue as in the numerous issue, and that's the issue of the issue raised by the claimant in his final address regarding the payments, the dollar payments, because the claimant made reference to the claimant's salary being $300,000 plus $2,000. My lord, in reply to that, strictly on law, my lord would rely on the case of CBN versus Denim. It's cited in our reply on points of law. The authority is a 2021 authority of the Supreme Court. And my lord, we're relying on it to say that, first of all, the claimants never denied the issue of alternate payments in our statement of defense. So that in itself is an admission. And by that authority, my lord, the claimant is stopped from relying or further retracting that admission to now re-argue that position to the detriment of the defendant. My lord, if they had an issue with that admission, if they had an issue with that averment or that pleading saying that the payments were alternate payments, my lord, they would have said it. They would have rebuffed it or denied it in a reply. My lord, the authority of CBN versus Denim is very clear on it, on both the fact that a party having not denied an averment in his pleading is deemed admitted and is also stopped from retracting that admission.
Yes.
So, my lord, we urge my lord to discountenance the submissions of the claimant in his written address on this head. And we urge my lord to dismiss the suit.
Thank you. Yes, Mr.
Yes, my lord. My lord, I take it that my written address has been adopted, my lord.
Yes.
Okay, I'm very grateful, my lord. My lord, in response to the submission of my learned friend, my lord, I want to clearly state that one, the letter of employment, which is Exhibit C1, speaks for itself. It is an elementary principle of law, my lord, that oral evidence cannot contradict a documentary evidence. My lord, Exhibit C is clearly stated to the claimant that you will be compensated with a monthly salary in the amount of 300,000 naira plus 2,000 naira, $2,000 paid via CSB on a quarterly basis of $6,000. My Lord, in our argument, we went ahead to define the meaning of plus to mean addition. To mean addition, and we relied, my Lord, on the case of OV Energy Marketing Limited to mean addition Marketing Limited and Alhaji Dairu, that Exhibit C is what the court will look at to determine the condition of service and terms agreed upon by the parties. And my Lord, Exhibit C1 clearly stated it. Oral evidence cannot contradict it. And my Lord, my learned friend stated that in their defense, we did not deny it. My Lord, we don't need to raise the issue again because it was not a new issue. We only need to reply on new issues. There is no law known that when a party says, I was not paid, and tendered documentary evidence to show that he was not paid, and the defendant come to say you were paid without raising new issues, there is no law that we must come back to that same issue. The issue my learned friend raised in his statement of defense are not new. They are not different. He did not raise any new issue that we need to show that, yes, we need to counter. He only said the statement that the Exhibit C1 did not show that the payment will be separated. Exhibit C1 speaks for itself. We don't need to bother the court again when the document is before the court. And the statement of account to show that the claimant was not paid was before the court. We don't need to raise that issue again to bother the court, my Lord. It is clear. And the law states that what the court should look at when there are conflicting views is the document, the terms agreed upon by the parties. And my Lord, I urge your Lordship to look at Exhibit C1. Exhibit C1, particularly the paragraph that says plus and old, that plus is an addition, it's not a separation, my Lord. And we urge your Lordship to enter judgment in favor of the claimant, especially on issue 3 in the final written address of the claimant. As the court pleases, my Lord.
My Lord.
Yes, please.
Yes, my Lord. If I may, my Lord, my learned friend has just alluded to the fact that there was no new issue in our statement of defense. My Lord, somebody says he's entitled to $300,000 plus $2,000 as his salary. My Lord, we say no. This money alternates. And my learned friend says that is not something worthy enough of a rebuttal. So that somebody comes to court with half-truths, and we come to court saying this is the exact position. There is no counter whatsoever as to the fact that these monies alternate so that they are not paid at once. And he says there is no need to deny that because it is not a new issue. My Lord, I would respectfully say that that is not the position, my Lord. My Lord, it is very germane to differentiate the modes of payment, so that if the claimant says, oh, it's okay to not deny the fact that these monies I'm claiming do not come together, they come alternates. They come in alternates based on where I'm working at any particular point in time. Then my learned friend is admitting to the fact that he presented half-truths to this court, and the argument as canvassed in paragraph 10 sub A to D is the actual position of how the claimants ought to be paid. So that, my lord, paragraph 10A states is clear argument on the fact that the money alternates. Paragraph B also draws reference to the fact that these monies, the claimants never requested for these monies before he went abroad, meaning he was aware that he was never entitled to those monies before he went abroad. He never disputed that. My lord, the paragraph 10 sub C says, alluded to the fact that the claimant only became entitled to this money when he started going abroad in 2010. My lord, another fact that he never disputed. My lord, that we now say that on paragraph D, he was paid his monies as at when due when he was abroad, and he was paid the Naira equivalent when he was in Nigeria. The claimant never disputed. My lord, it is even interesting to note that the claimant is not even asking for the alternate, the Naira salary that he wasn't paid for the period he was in abroad, that he was receiving the dollar payments. So that my lord will see that the argument as captured in the pleadings of the defendant is the actual position of the case. My lord, it is elementary to state that parties, the cases of parties are structured and rooted in their pleadings. So they cannot go outside their pleadings to say what they think or what they do not, or whatever they like. So that my lord, by accepting our pleadings, they cannot now come around to now rebut what they have already accepted as true. My learned friend, the claimant's counsel has already even admitted to the fact that as it stands now, they are in acceptance of paragraph 10 sub A to D of the defendant's.
That is not correct, my lord. That is not correct, my lord. That is not correct.
Which is to the fact that there's nothing new. There's nothing new that was raised in what he said. There's nothing new that was raised that required rebuttal, which simply means that the paragraphs as contained in the pleadings are the actual position of the parties, so that it is not new and it is not strange to them that that the payments do not run concurrently but alternate.
My lord, I'm sorry. I think my learned friend.
I've heard the arguments. Much as I would have been more interested in hearing reply on points of law, but you just made a resubmission of what you stated earlier.
Yes, my lord. That's why, my lord. If my lord looks at our paragraph 2.11 in our statement, in our reply on points of law.
I've looked at everything.
As the court please.
I've looked at everything. It was forwarded to me in writing.
As God pleases.
Written before me. Well, I had the opportunity of looking at all your arguments before now, and my judgment is ready.
As God please.
If you are interested, I will go ahead to read my judgment.
Very well, my lord.
The summary goes as follows. The claimant was employed by the defendant as its group finance and administrative manager. I'm sorry. This is Ikechukwu, right?
Yes, my lord.
Yes, my lord.
Judgment. This claimant was first employed by the defendant oil servicing company on the 3rd of February 2007 as its district manager in Port Harcourt until the 1st of February 2016, when his employment was terminated by the defendant. Based on the contents of his letter of employment, he was initially employed on a fixed monthly salary of 300,000 naira which was subsequently reviewed upward to 400,000 naira, plus $2,000. Now, before the termination of his employment, however, the defendant allegedly owed the claimant unpaid salaries of $2,000 per month for a period of 35 months from March 2007 to January 2010, which accordingly totals $70,000. Also, the claimant allegedly worked for 236 days at the defendant's foreign facility in DR Congo for an agreed salary of $2,000 every 30 days for the periods between the 1st of October 2015 to the 29th of November 2015. The claimant asserts that the defendant did not pay the said $2,000 per month for those periods, which he calculated in his amended rate to be $15,731.76 US. Upon the termination of his employment, the claimant wrote through his solicitor a demand letter for his purported entitlements and unpaid salaries of a total of $85,731.76, which the defendant company allegedly adamantly withheld or refused to pay to date. Hence, the claimant has approached this court seeking the reliefs as per his writ of complaint. Now, this claimant's complaint and accompanying processes were originally filed on the 24th of November 2016. However, with the leave of this court, they were later amended and substituted with processes filed first on the 27th of March 2018 and again on the 23rd of January 2020. Within, the claimant seeks the following reliefs. 1, a declaration that the claimant is entitled to the sum of 12,494,871 naira and 85,731,000 US 76 cents, being his terminal benefits from the defendant as per the terms and conditions of service for senior staff between the claimant and the defendant. 2, an order directing the defendant to pay the sum of 12,494,871 naira and 85,731 US 76 cents to the claimant. And thirdly, the sum of 400,000 naira, being the claimant's monthly salary from the first day of November 2016 until the claimant's terminal benefits are fully liquidated. The claimant opened his case on the 21st of February 2017, wherein he testified for himself as CW1 and tendered 12 documents in all, admitted as exhibits C1 to C12, whereupon he closed his case on the 3rd of February 2021. He was thereafter duly cross-examined by the defendant's counsel. The defendant initially filed its statement of defense and accompanying processes on the 29th of June 2017. This was consequentially amended on the 1st of July 2020. Upon receiving the defendant's statement of defense, the claimant relied on his filed reply of the 11th of July 2017 as his response to the statement of defense. After several fruitless adjournments, the defendant eventually opened and closed his case on the 3rd of February 2021, calling and relying on the testimony of one witness, one Johnny Olisakwe Maduafokwa as DW1. He was duly cross-examined by the claimant's counsel thereafter. At the conclusion of trial on the 3rd of February 2021, the parties' counsel were ordered by this court to file their final written addresses and submissions within the required time frame provided by the rules of this court. Consequently, the Defendant's Counsel filed his final written submissions and arguments on the 25th of June, 2021. The Claimant's Counsel, however, filed his on the 13th of January, 2022, way out of time. This was later substituted by another written submission filed on the 21st of March, 2022. The Claimant's Counsel applied to withdraw his earlier final written submission and address, and for leave to enlarge the time for filing and to same as duly filed and served on the 21st on the 14th of February 2023. This court granted his requests. Meanwhile, the Defendant's Counsel, upon being served with the claimant's address, also opted to file a reply on points of law on the 9th of February 2023. Eventually, the parties' counsel successfully adopted their respective positions on the 14th of February, that is today. This court immediately proceeded to deliver these judgments virtually. One of the main reasons for the delay in concluding this matter is that the Owerri division was indefinitely shut down by order of the president of this court on the 3rd of June 2022 due to an unrelated issue that threatened the existence or the safety of the personnel of the courts. Having only been reopened on the 9th of January 2023, the parties were immediately notified by the court's registrar to appear on the 7th of February 2023 for the purpose of adopting their final addresses. However, it was not until the 14th, that is today, that the parties' counsel successfully adopted their respective arguments and submissions virtually, finally bringing to an end this 6-year dispute. I will go straight to the reasoning and my findings.
As a copy, please.
Court's decision. I painstakingly read through the written submissions by learned counsel in line with the issues for determination raised by them. This court is convinced that the answer to the question whether the claimant is entitled to the sum of $85,731 as his unpaid and outstanding salaries for the period he worked for a defendant company is sufficient in determining the suit. Thus narrowed down, I shall proceed to determine this issue on the strength of the facts, evidence, and the laws presented before this court by both parties. It is clear from their pleadings that issues were joined on the said claim for the sum of $85,731 made by the claimants. For clarity, I shall reproduce the salient paragraphs from the statement of facts and the statement of defense before resolving the sole issue for determination. As per his amended statement of facts, the claimant avers under paragraphs 3, 4, 14, and 15 as follows, and I quote. 3. The claimant was employed by the defendant on the 3rd day of February 2007 as the district manager, Port Harcourt location, with a monthly fixed pay of 300,000 naira plus $2,000. The claimant's letter of employment shall be relied upon at the trial of this matter. Paragraph 4. The claimant avers that he was not paid the $2,000 per month for 35 months, which is for the period of March 2007 to January 2010, which brings the total sum to $70,000. 14. The claimant avers that due to his great input to the defendant, he was posted to the defendant's branch office at Congo with an additional salary of $2,000 for 30 days. And he worked for the period of the 1st of October 2014 to 29th November 2015 without payment of his salary. 15. The claimant avers that he worked in the defendant's office in Congo for 236 days, and he was not paid for the period he worked, which sum amounts to 15,731 US dollars. The denials within the defendant's amended statement of defense are contained in its paragraphs 10A, 10B, 10C, and 10D, and these are also reproduced below. Now, the law is long settled in our civil jurisprudence on whom the burden of proof lies in any civil suit, and the extent to which a litigant must prove his case to merit the decision of a court in his favor. Accordingly, it is well engraved within our evidential laws that whoever desires any court to give judgment on any purported legal right or liability dependent on the existence of facts which he asserts must prove that those facts exist. Section 131 of our Evidence Act is a foresight. More so, it is instructive that the burden of proof in a suit or proceeding lies on that person who would fail if no evidence at all were given on either side. You may see Section 132 of the Evidence Act. It is equally desirable to emphasize that the state burden of proof must be discharged on a balance of probabilities in all civil matters. You may see Section 134 of the Evidence Act. The claimant in this suit tendered Exhibit C1, which is his letter of employment, and placed heavy reliance on same as the contractual instrument that regulated his relationship as an employee of the defendant at all times material to this suit. Undoubtedly, the true interpretation and application of Exhibit C1 are germane questions at the heart of this suit. Interestingly, the importance of the letter of appointment or employment cannot be understated in the type of employment in this instance suit, which is that of a simple master/servant. The decision in Union Bank of Nigeria, petition supplied, is illuminating on this point, and same merits clear reproduction as follows. It is supplied under. I find as a fact that the relief sought by this claimant before this court is inextricably woven around the contents of Exhibit C1. Hence, the salient excerpt from Exhibit C1 is reproduced as follows. Title: Letter of Employment, Appointment as District Manager, Group Operators with Port Harcourt Base. We are pleased you have agreed to accept our offer of employment as discussed. You will assume the position of District Manager in our Port Harcourt location, reporting directly to Kashmir Maduafokwa, CEO. This letter will serve to confirm our understanding of your acceptance of this position. Your responsibilities will be those underlined or outlined in the enclosed job description. You will be compensated with a monthly salary in the amount of 300,000 Naira plus 2,000 US dollars, with the dollar option paid via SCB on a quarterly basis of 6,000 US dollars. This covers your basic plus housing. A car plus driver self-retained with 15,000 Naira per month will also be provided, etc., etc. It is important to reckon with the renowned position of the law that contracts of a purely master and servant relationship, as in this case, are governed by the mutual and exclusive agreements between the contracting parties. CBN versus Iguilo, so it's an authority on this. This is the essence of the maxim pacta sunt servanda. Agreements must be kept. It therefore follows that in the absence of any other contractual document before this court, and having been unquestionably admitted in evidence, Exhibit C1 shall be attributed full evidential value and weight as a contract document that regulated the master and servant relationship between this claimant and his defendant. So, the claimant first claims the sum of 15,000 US dollars. as the total of unpaid salaries for the 236 days that he allegedly worked at the defendant's facility in Congo DR. According to the claimant, he worked from the 1st of October 2014 to the 29th of November 2015 without payment of his salary in US dollars for those periods. This abandonment is contained both in his statement of facts and evidence in chief, seen from his sworn deposition. However, under cross-examination, the claimant answered thus. Question: while in Nigeria, you were paid in Naira, and while abroad, you were paid in foreign currency. Answer: I was paid in Naira in Nigeria. I was partly paid in dollars when abroad. Question: when you started going abroad, you began receiving dollar salary. Answer: not frequently. These answers given by the claimant attend the mind of this court with alarming contradictions. The pleadings of the claimant and his evidence in chief suggests that the claimant was never paid for the periods he worked at the defendant's facility in Congo DR. Whereas under cross-examination, the claimant stated that he was paid partly in dollars and that his salaries were infrequent. In the face of this palpable inconsistency in the evidence of the claimant, I find it difficult to believe that he was not paid any salaries whatsoever for the duration he worked at the defendant's facility abroad. Also, it is manifestly unclear from the overall evidence adduced by him those specific months he received salaries from a defendant for works allegedly done in Congo DR, and the months he was allegedly unpaid. And since this court cannot go on a speculative voyage in order to fill in the gaps in the claimant's case, it shall be safe to presume that he failed to convince this court minimally. Insofar as the claim that he was not paid for the periods he worked for the defendant in Congo DR are unsubstantiated, same must be discountenanced by this court, and I so hold. Now, secondly, the claimant in this suit claims in paragraph 4 of his amended statement of facts that he was never paid $2,000 per month for 35 months, which is for the periods of March 2007 to January 2010, totaling $70,000. Interestingly, too, the claimant contends that from the beginning of his employment to January 2010, a span of 3 years, the defendant company never paid him the said $2,000 along with his salary in Naira as per his contract of employment. The crucial question to ask at this juncture is whether the claimant is entitled to the said sum of $2,000 per month ab initio. I recollect that the defendant animadverted that the claimant was not entitled to the said $2,000 per month for work done within Nigeria, but rather the said $2,000 were his salaries per month for works done by him in the defendant's facilities abroad. There is no gainsaying that this court was invited to determine the true purport of Exhibit C1. It is right that where words used in a document are plain, the court must restrict itself to their ordinary meaning without any importation thereto. In the first place, there is nowhere within the entire length and breadth of Exhibit C1 where the allusion for payment of monthly salaries in a foreign denomination for any work in the defendant's facility abroad can be inferred. I find it very difficult to agree with the defendant that the claimant's work abroad is contemplated in Exhibit C1. I shall again reproduce the exact line from Exhibit C1 on the reference, which is thus, and I quote, monthly salary in the amount of 300,000 Naira plus $2,000 with the dollar option paid via SCB on a quarterly basis of $6,000. This covers your basic plus housing, leave allowance, and Christmas bonus of 300,000 naira plus 2,000 US dollars each will be paid. Close quotation. Generally, where an employment contract is nebulous or ambiguous, it will be construed most strongly against the party preparing it or employing the words concerning which doubt rises. Now, this rule applies to contracts prepared by the employer or by the employer's representative, such as his or her attorney. A standard rule in labor law is that ambiguity must be resolved in favor of the employee. However, from the relevant portion of Exhibit C1 above reproduced, it is clear that the claimant was employed by the defendant to work at a specific address in Nigeria. Hence, the title of the contract document provides thus: Letter of Employment, Appointment as District Manager, Group Operations with Port Harcourt Base, close quotation. This does not seem to presuppose any other schedule of work abroad. The argument of the learned defense counsel to the effect that the claimant knew all along that he was meant to work both in Nigeria and abroad, and also to receive Naira currency in Nigerian dollar equivalents when working abroad is most untenable. This is especially in the face of the first paragraph of Exhibit C1, which reads, "We are pleased you have agreed to accept our offer of employment. As discussed, you will assume the position of district manager in our Port Harcourt location, reporting directly to Kashmir Maduafokwa. This letter will serve to confirm our understanding of your acceptance of this position." End of quote. It is difficult to fathom how, by any stretch of imagination, the contract's express consideration of a monthly 300,000 naira plus 2,000 US dollars for work done in the said position as district manager in Port Harcourt location should be interpreted to mean 300,000 naira for work done in Nigeria and $2,000 for work done abroad if the said contract did not specifically provide so. If the latter interpretation is by any means what the defendant intended to communicate ab initio, which I have a strong reservation that it is, then the defendant must have itself to blame for its unintelligible legal dexterity in drafting the said document. So, as for the claim in virtue of Exhibit C1, the claimant must prove that he is entitled to these amounts and that the defendant failed to pay him or pay him same for 35 months, that is 2007 to 2010, or for the entire 9 years of his employment in the defendant company. The defendant certainly would need more than just mere grammar to convince this court that the said $2,000 is an alternate salary for work to be done abroad by the claimant. Nonetheless, I am not unmindful of the defendant's averment that the claimant never demanded for the said $2,000 at all throughout his employment period with the defendant, therefore implying that he, at all material times, knew that he was not entitled to the same $2,000. I am also not unaware that under cross-examination, the claimant answered that he made oral demands for the said money allegedly earned by him. Curiously, I wonder if the claimant ever received any $200,000 along with his leave and Christmas allowances in accordance with this contract of employment. That is Exhibit C1. It seems he left out this very special and vital piece of information for reasons which I cannot possibly speculate on. Again, assuming even that no such demands were made by the claimant, I do not subscribe to the line of defense by the defendant that same must be construed as constituting an understanding between the claimant and the defendant that the sum of 2,000 US dollars stated in Exhibit C1 is meant to be an alternate salary for work done abroad by the claimant. In the list all the defendant has raised is a possibility of whether or not to believe that the claimant was not paid his 2,000 monthly salary, which I already found is meant to be in addition to 300,000 naira, later reviewed to 400,000 naira by the defendant per month, as per the contract of employment. Therefore, has the claimant been able to satisfactorily prove that he was not paid 2,000 US dollars for 35 months while he was working in a defendant company from 2007 to 2010 to be entitled to the sum of 70,000 US dollars? Being in the nature of a special damage, the claimant is required to adduce unbridled evidence based on pleaded facts to prove his entitlement to it. This claim is one that is of a special kind. The law is right that a claim for special damages must be specifically pleaded and strictly proven. Special damages are also called compensatory damages. They are based on a measurable naira amounts of actual losses, and it is for this reason that they are expected to be specifically pleaded and proven. Thus, to be entitled to this relief, a claimant is expected not only to plead the facts relating to his head of relief, but he must also adduce credible evidence in support of same. Documentary evidence has been adjudged to be the best evidence by a plethora of cases. There are several of them. You will go through them if you want. It goes without saying that documentary evidence is the hanger upon which oral testimonies are assessed. On the strength of the foregoing authorities, it must be emphasized that Exhibit C1 has a voice that speaks for itself. Meanwhile, the parties are in unison on the fact that the claimant's salary was reviewed and increased from 300,000 to 400,000 monthly in 2010. I have no problem with that. The claimant tendered and relied on Exhibit C5 in proof of this same increment. A cursory assessment of Exhibit C5, however, shows that the claimant was entitled to the following benefits. It's headed terms rotation. Sorry, I did get that. 30. Anyway, it's listed there. We'll go through it. Now, from the contents of Exhibit C5 above, it is evident that for the first time in the employment of the claimant, the nomenclature PNR salary was used on the 30th of January 2010. Hence, the inference by the defendant that the payment of $2,000 for work done abroad originally emerged in 2010. In my honest view, in order for the claimant to convince this court that he was not paid those portions of his entitlements in the US dollar denomination whatsoever prior to the 30th of January 2010, he must adduce positive and cogent evidence of such non-payments, sufficient enough to convince this court that he never received them. One of such ways to do so would be by producing the statement of his salary accounts or pay slips as evidence to establish that whereas he received his monthly salaries in the naira currency, the other portion, which is the dollar, was never paid to him. It would also have assisted his courts if he had established how he repeatedly made demands for payment of his full salary arrears from the defendant so as to convince this court that he never slept over or waived his claims, which, like he said, were for successive 35 months in total. So, for what is worth right now, it is the claimant's words against the defendants. I did consider Exhibit C9 carefully, which is accordingly the claimant's first bank domiciliary account number, starting with 20 and ending with 612. Same is, however, not corroborated by any other piece of evidence that it is the account he opened for the purpose of receiving his salaries from 2007 to 2010, particularly since he did not provide his main salary account for the purpose of cross-referencing when he was paid such or each month against the entries on Exhibit C9. Besides, Exhibit C9 is not the SCB account expressly instructed in Exhibit C1 to be where the claimant's dollar salaries should be deposited into. The claimant never afforded any reasons why he tendered the First Bank of Nigeria domiciliary account instead, and so this court cannot make any speculations in any regards. It is thus difficult for this court to understand why and how he should succeed on the weakness of the defendant's case, whereas he has not produced convincing facts and evidence to sway the court in granting his claims. In view of the foregone, I find that the claimant was unable to establish by credible evidence before this court that he is entitled to the sum of $85,731 76 cents, being the gross total of alleged unpaid salaries while he was employed by the defendant, and as provided for in Exhibit C1. The evidence produced by him in this case are scanty, weak, incongruous, and do not support the granting of this isolated relief. As such, it is safer to resolve the sole issue for determination in favor of the defendant, and I so hold. As for this claimant's claim to the sum of 12,494,871 naira, being the balance of his terminal benefits owed him by the defendant, this claim is based on the perception that the terms and conditions of service for senior staff of the company, which he tendered as exhibits C10, C3, C10, and C11, were incorporated into his contract of employment when he was employed to a management position in the defendant's company. The claimant's counsel had argued that the incorporation of those conditions of service was done verbally when the claimant was informed by the HR manager then, that's Musa, that his salaries, advances, and terminal benefits would be based on the conditions of service for senior staff. This was, however, not stated by the claimant himself in his pleadings or sworn deposition or in open court while he testified. Remarkably also, the witness never mentioned or bothered to call in the said Mr. Musa to corroborate this vital piece of fact. No amount of rationalization by the claimant's counsel can convince this court to allow this wanton fact as evidence, since he is simply supplying evidence on behalf of his client in his final submissions. I agree with the defendant's counsel, therefore, that arguments or addresses of counsel, no matter how delicately and beautifully presented, cannot take the place of evidence. Therefore, the claim that one Musa of the HR department informed this client or this claimant that the terms and conditions of service for senior staff are incorporated into his letter of employment is an incurable and an inadmissible second-hand or hearsay evidence. It is hereby jettisoned with prejudice, and I so hold. In any event, as determined by my brothers Bashar and Haman J. of the Yenagoa and Port Harcourt divisions of this court in 2 cases respectively, I hold that the claimant, not being a senior staff member of the defendant company, is not entitled to make and or benefit from any claims derived from the conditions of service for senior staff, which he had tendered as exhibits C3, C10, and C11 in this suit. Accordingly, and in light of all the decisions and the opinions held by this court in the above-mentioned cases, which I equally adopt as a basis for my decision on this question here, the claimant's sum of 12,494,871 naira is hereby denied. The flip side, however, is that since the claimant's employment was terminated by the defendant, he is entitled to have been given at least a month's notice before the said termination, or be paid a month's salary in lieu of the termination if the defendant has not already paid same before he instituted this matter. I hereby order the payment of this 1 month or of his 1 month salary in lieu of the notice of termination if same had not already been advanced to this claimant. Even if this is not expressly claimed, this court can still award it Since the law is that where a servant's employment is terminated, he is entitled to be paid all outstanding monies owed, including any salary in lieu of the required notice before such termination. Consequently, this claimant's suit fails entirely. Judgments are accordingly entered against him. His claims are dismissed for the reasons set out above.
As the court pleases. My lord, we're most obliged, we're most grateful for my lord's well-considered judgment.
You're welcome.
My lord, we are very grateful for the wonderful judgment. We are grateful, my lord.
You'll get a copy immediately after proceedings today, and you read it within 5 minutes online.
As the court pleases.
Thank you. Now we have the last matter. Shall we call it?
The last one. Yes, my lord.
Yes, I'm ready. Simon?
Yes, my lord. Suit number NICN/YEN/440/2016 between Mr. Samuel Chibuzoezi and Tecon Oil Service Limited. Thank you, my lord.
Yes, my lord. M.U. Ejua, and for the claimant, my lord.
All right. No, sir. But for the defendants.
Want to add something?
Sorry, my lord.
No.
Anything to say?
No, my lord.
All right. I will take it on record that you both adopted your respective final written addresses.
As the
court pleases.
Okay. Since it's a constitutional requirement for judgments to be read openly, I have no choice but to do so.
As the court pleases.
Judgment is ready, and in light of the other matters, I believe probably know how it might end. Here are the facts of this case. The claimant was employed by the defendant as its group finance and administrative manager on the 5th of May 2002, and he worked in that capacity until the 1st of February 2016, when his employment was terminated by the defendant. Following his disengagement, the claimant was paid a sum of 8 million naira only as his terminal benefits. Being, however, dissatisfied with this amount, he demanded for what he believed to be his actual entitlements from the defendant company, allegedly the sum of 29,958,173 naira and 8 kobo, via the letter dated the 11th of July 2016. I beg your pardon, instead of 11.
Sorry, my lord.
It's all right. His demands unmet, he thus approached this court for a redress of what he considers as a determined withholding of his due entitlements by the defendant company. Please permit me to go straight to the decision portion.
As the court please.
Court's decision. I carefully read through the final written submissions by both counsel in line with their arguments on their issues for determination. I equally evaluated all the evidence adduced in this suit. Having joined issues and concluded trial, it is incumbent on this court to make its findings based on all that has been presented. As such, I am satisfied that the sole issue for determination should be whether the claimant is entitled to the sum of 25,614,424 naira and 0 kobo claimed. I shall determine this sole issue on the strength of the facts before this court emanating from evidence adduced by both parties. Before delving into the kernel of this issue for determination, it appears apposite to state at the earliest opportunity that the claimant and the defendants already agree on the existence of certain facts. It is instructive from the pleadings of both parties and issues were joined on the facts culminating into the claimant's claim for the sum of 25.6 million naira. The facts referred to are contained in paragraph 17 and 18 of the claimant's statement of facts. It is provided below. The claimant is apparently bothered by the alleged willful shortchange to his terminal benefits by the defendant. He did, in fact, as per Exhibit C7, express this displeasure to the defendant. In the said Exhibit C7, the defendant demanded for the total sum of 29,958,173 naira and 8 kobo as his terminal benefit. The law is not settled on whom the burden of proof lies in any civil suit, and the standard to which a litigant must prove his case to merit the decision of the court in his favor. Accordingly, it is well engraved in our evidential laws that whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove that those facts exist. In proving his entitlement to the sum of 25.6 million naira, the claimant particularly tendered and relied on the following documents. 1, the claimant's letter of employment dated 5/5/2002, Exhibit C1. 2, condition of service, Exhibit C3. 3, communiques dated the 14th of November 2013 and the 23rd of January 2004, Exhibits C4A and C4B. 4, conditions of service 2002 to 2004, Exhibit C8. 5, conditions of service 2004 to 2006, Exhibit C9. 6, conditions of service 2006 to 2008, Exhibit C10. And 7, conditions of service 2008 to 2010, Exhibit C11. Now, so unless and until there are credible express or implied evidence to suggest that a contract of employment was amended verbally by an employer, or that certain terms which were verbally made were impliedly incorporated into such contract of employment, the law still remains that the contents of a written document cannot be amended orally. It is the general law that where parties have embodied the terms of their contract in a written document, extrinsic evidence is not admissible to apply or to add, subtract, or to contradict the terms of the written document. I therefore fail to see how exhibits C3, C8, C9, C10, and C11 were incorporated verbally into this claimant's written employment terms, as testified by the claimant and as argued furtively by his counsel. If the claimant wants this court to believe him, then perhaps he should have corroborated his testimony with that of the human resources manager, who was accordingly responsible for making the representation that Exhibit C3 would be binding and enforceable on him, or by producing other pieces of credible evidence in that regard. I respectfully reject the unconvincing submissions and arguments made by learned counsel for the claimant on this issue. Besides, I quite agree with the defendant's counsel that the arguments made by the claimant's counsel on the said above issue are unsupported by any facts in the claimant's pleadings. Arguments or addresses by counsel, no matter how delicately and beautifully presented, cannot take the place of evidence. Therefore, the claim that one Musa of the HR department informed this claimant that the terms and conditions of service for senior staff are incorporated into his letter of employment is an incurable defect and a second-hand Tokumbo hearsay evidence. Meanwhile, the claimant found his claims on a supposed calculation derived from the conditions of service as by exhibits C3, C8, C9, C10, and C11. These documents have boldly written on each of the cover pages conditions of service for senior staff. The claimant stated under cross-examination that his letter of appointment, Exhibit C1, implies that he will benefit from the senior staff conditions of service. It is unassailable that Exhibit C1 provides for the possibility of other terms and conditions. At least the last paragraph thereof states clearly, other terms and conditions including general compensations, would also apply. But should this expression be construed as clearly envisaging the application of the conditions of service for senior staff, which he tendered? Certainly not. To decide otherwise would be tantamount to altering the contract between these parties, and that is not one of the duties of this court. This stance is fortified by the statement of the claimant under cross-examination, which I deem apposite to reproduce hereunder as follows. 1. Question. You were a management staff of the defendant? Answer, yes. 2. Question. Do you agree that there is a difference between management staff, a senior staff, and a junior staff? Answer, yes. But in TECON, the managers have no conditions of service, and everything was based on the senior staff conditions of service. 3. Question. You are employed as a management staff and not a senior staff? Answer, yes. I was a management staff. 4. Question. You are not a unionist? Answer, I am not. I'm a management staff. 5. Question. You don't belong to Pengerson? Answer, no, I don't. There is no doubt that exhibits C3, C8, C9, C10, and C11 are all labeled conditions of service for senior staff. Meanwhile, exhibits C4, A, and B are communiques resulting from meetings had with the management staff of the defendant and the members of both unions of Pengerson and NUPEN, respectively dated the 14th of November 2013 and the 23rd of January 2004. The claimant never suggested that he was at any point in time a member of any of those unions or that his name was stated in any of those documents he tendered, to infer that the contents of these documents are binding by him. As my Lord Hammond J. most recently puts it in his decision in Inform Michael, Jeremiah versus TECON Oil Service, I quote, it is clear from the claimant's evidence that he was not a member of either Pengerson or NUPENG. If one of the ways of determining membership of a trade union is the payment of union dues, I then wonder how someone whose salary was never deducted for union dues and never paid such dues can claim membership of a trade union. End of quotation. You may also see the case delivered by my learned brother Bashar J. in Emeka Ben of Bielemba versus TECON Oil Service, citation supplied. Significantly, exhibits C11 as well as exhibits C3, 8, C8, and C10 all contain the following clauses or clause, and I quote, this agreement is made on the 12th day of February 2009 between Petroleum and Natural Gas Senior Staff Association of Nigeria Pengerson, TECON branch, herein called the association, and TECON Oil Service Nigeria Limited, hereinafter called the company. Clause 3 of Exhibit 3, Conditions of Service for Senior Staff 2011, states as follows, I quote, the terms set out in this agreement shall be binding on the company and all regular employees of the company who are members of this association, that is Pengerson. There is no gainsaying that this evidence is in the least self-defeatist as it emasculates the case of the claimant, since it is crystal clear that the claimant is not a member of the association, that is Pengerson, the body contemplated in the conditions of service for senior staff. It is thus baffling why he seeks to benefit from enforcing the judgments or provisions of the state agreement in computing his terminal benefits bid formulae contained in those documents. This seems like a desperate venture on his part. It is right that only a party to a contract or agreement can enforce same, even if it was made for his benefit. It is also right that where words in a document are plain, the court must restrict itself to their ordinary meanings. Yes. Now, for the obtained time, exhibits C3, C8 to C11 are unhelpful to the claimant's case. As such, building his claims upon those exhibits amount to constructing mansions on thin ice. Just like the wolf said to the poor three little piggies, the law will surely puff, and blow away any claims not soundly rooted or founded on it. This, rightfully, is the fate of the claimant's claim. In any event, this claimant seeks for an order of this court to compel the defendant to pay him the sum of 25.6 million naira, being his supposed terminal benefit in virtue of the terms and conditions meant for senior staff of the defendant company, either of exhibit C3, C8 to C11. This court has taken cognizance of the contents of exhibit C7, the claimant's letter of demand for his due terminal benefits from the defendant. Curiously, this document puts the purported entitlements of the claimant at the sum of 29.958 million naira. It is, however, not clear from the content of the said exhibit C7 the formula adopted by the claimant in arriving at the figures demanded therein. The question, therefore, is how exactly has the claimant been able to prove his entitlement to the relief sought? By our evidential law, the claimant carries with him an evidential burden to prove his case on a balance of probability. While being put through the furnace of cross-examination, however, the claimant actually admitted that his entitlements while working with the defendant was never based on any of the conditions of service for senior officers. I dare to think that the claimant left so much to be desired in this suit. I wish to add here too that it is until the said orders of proof is discharged by the claimant, the defendant will have nothing to disprove. Now, the flip side, however, is that since his employment was terminated by the defendant, he is entitled to have been given a month's notice before the said termination, or be paid a month's salary in lieu of the termination if the defendant has not already paid same before he instituted this matter. I hereby order the payment of his 1 month salary in lieu of the notice of termination if same had not already been advanced to this claimant. For the entire quantum of evidence before this court, and in view of the foregone, the sole issue for determination in this judgment is bound to be resolved against the claimant and in favor of the defendant, and I so hold. In all, the claimant's suit fails, as this court is not convinced that he is entitled to the reliefs sought. The sole issue for determination having been answered against the claimant and in favor of the defendant, this suit is hereby dismissed without costs. Judgment is accordingly.
As God pleases. My Lord, we're most grateful for my Lord's will.
Equally welcome. I have copies of the judgments, and they will be given to you by the registrar of the courts in the Owerri division, and you can read them immediately after proceedings today.
As God pleases.
Are there any other applications that I need to take?
No, none from our part, my Lord.
All right. Clerk, registrar.
Yes, my.
Any other case, any other application?
Nay, my lord.
Any announcements?
We are still the way we are, my lord.
All right, good luck to you. I wish you all the best.
As God pleases.
Thank you.
I shall rise.
God.
Bye-bye. Hey, good.